All right, let's dive into a foreclosure case that, frankly, every legal and real estate professional really ought to know about. It's got everything: alleged forgery, totally contradictory legal arguments, and a homeowner who, thanks to his unique background in secure software, uncovered a paper trail that stretches all the way back to the 2008 financial crisis. Now, this isn't some hypothetical questioning from law school. This is the central, mind-bending paradox of this entire case. It really forces you to ask, how can a lender possibly foreclose on a property when their very own public records show the debt was settled over a decade ago? So, our story doesn't start where you'd think, back in 2008 with the original loan. No, it starts in 2019. This is the moment a really strange and, frankly, audacious request from a loan servicer pulled a single thread that started to unravel this whole thing. Picture this: it's 2019, and the loan servicer, Carrington, sends homeowner Jeremy Bass a stack of documents, and they ask him to sign them as if it were 2012. Now, this wasn't just some minor correction. We're talking about a 7-year backdating request, a move that, as you can imagine, immediately set off all kinds of alarm bells. And the red flags just kept piling up. I mean, the documents had his ex-wife's name on them. She was never even on the loan. They also listed Carrington as the servicer for a time period years before they actually took over. And when Bass refused to sign, they just kept sending more versions, calling constantly, and even dangled a $100 incentive. This wasn't just sloppy work, right? This was a high-pressure campaign to try and retroactively fix a broken paper trail. So all this suspicious behavior got Bass to do something most homeowners never do. He launched a deep forensic audit of his own property records. And what he found from over a decade earlier, well, that turned out to be the source of Carrington's desperation. Okay, before we go any further, we've got to get on the same page about this crucial document. A letter of full reconveyance is, for all intents and purposes, a mortgage's death certificate. It's the official public record that a debt has been paid in full and the lender's claim on the property is gone. And here's the key: it is not what you use when a loan is simply sold or transferred to another bank. And this is why that definition is so critical. Just look at this timeline. In 2008, Bass gets his loan from Zions Bank. Simple enough. A year later, a new loan document with Bank of America pops up. But then, and this is the wild part, just a few weeks after that new loan appears, the original Zions loan is officially marked paid in full with that letter of full reconveyance. In a standard loan transfer, that sequence makes absolutely no sense. This really gets to the heart of the whole problem. A normal, totally legal transfer uses something called an assignment of mortgage to pass an existing debt along. But in Bass's case, they created a whole new deed of trust and then issued a full reconveyance on the original one, which legally killed it. See the difference? One process transfers a debt, the other one declares it dead. And then there's the money side of it, which is just as puzzling. Bass said he barely even qualified for his first FHA loan. So given the strict debt-to-income rules, it would have been pretty much impossible for him to qualify for a second simultaneous FHA loan for a similar amount just a year later. This wasn't just a paperwork anomaly, it was a financial impossibility. So as Bass kept digging, he found something that just blew the case wide open. This wasn't some one-off clerical error. He found a legal precedent, a case involving the exact same bank and the same bizarre procedure that put his whole situation in a brand new light. I mean, just look at this. The parallels to this other case, Countrywide v. Sheets, are staggering. Same bank, same action, a full reconveyance, signed by the same person, notarized by the same person, all happening within hours of each other. But here's the kicker, the absolute contradiction. In the Sheets case, Bank of America argued the reconveyance was just a mistake. In Bass's case, they're arguing the exact opposite, that it was valid. You just can't have it both ways. And the Supreme Court of Idaho was basically mystified. In their ruling on the Sheets case, they pointed out that the homeowner couldn't really explain an ulterior motive for why the bank would do something like this. So the court saw the smoke, but Sheets couldn't point to the fire. And that left the door wide open for Bank of America to just claim it was some bizarre one-time error. Okay, so that brings us back to the present day. With all this messy, contradictory history lurking in the background, the modern servicer, Carrington, starts this campaign of pressure, and it's all designed to clean up the past by putting a squeeze on the future. First up, they use the pandemic. Bass was put into a COVID forbearance for 24 months. Now, the legal maximum under the CARES Act, 18 months. That extra 6 months wasn't a favor. It was a tactic. It let the arrears pile up to an impossibly high number, which created the maximum amount of financial leverage over him. So when you lay it all out, you can see their playbook, step by step. First, try to get him to sign backdated documents. When that doesn't work, illegally extend the forbearance to rack up a huge debt. Then use that massive debt to try and force him to sign a brand new loan modification. And when boss refused all of it, well, they had no choice but to try and foreclose using the very same document they'd been trying so hard to replace. At the end of the day, the backdating attempt in 2019 and the loan modification ultimatum in 2022 had the exact same goal: get Bass's fresh signature on a new document and just wipe away all the problems with that original 2009 paperwork. All right, so we've got this questionable document from 2009 and a modern-day pressure campaign. Now let's connect all these pieces and see how they form the absolute core of Boss's argument, that the entire foreclosure was built on a foundation of fraud. And this is where it gets really good. In court, the trustee's own lawyer made a fatal admission. They stated that the 2009 Letter of Full Reconveyance was valid. I mean, just think about that for a second. If the document that extinguished the original loan was valid, then that loan was legally paid off. This admission creates a paradox the bank just can't solve. How can you foreclose on a debt that your own representative admits was already paid in full? And you have to remember, this kind of behavior doesn't happen in a vacuum. Between 2008 and 2014, Bank of America shelled out tens of billions of dollars in settlements for everything from predatory lending to selling faulty mortgages. So the conduct being alleged in Bass's case isn't some outlier. It fits squarely into a well-documented, systemic pattern of mortgage misconduct from that whole era. Now, what makes this case so incredibly unique is the plaintiff himself. Jeremy Boss isn't just any homeowner. He spent 30 years as a senior developer for secure financial and administrative software systems. He was literally professionally trained to spot the exact kind of document and data manipulation he alleges was used against him. And that expertise led him right here, to the signature itself. A forensic comparison shows that the B in his last name on that disputed 2009 document is structurally different from his verified signatures on countless other legal documents. This isn't just a feeling he has, it's tangible evidence that points directly to forgery. And as this legal expert explains, a forged signature isn't some procedural hiccup you can just fix later. It is a foundational flaw. If the very document that gives the bank the right to foreclose was never validly signed in the first place, then the entire legal basis for that foreclosure and the subsequent sale of the property could be completely void. You know, when you step back, you realize this entire case is really a ghost of the 2008 financial crisis. The rushed securitization, the sloppy transfers, the robo-signing scandals, all of that created a whole generation of flawed documents. This legal battle is a direct consequence of that chaos, finally coming to a head more than a decade later. Which leaves us with the essential question, the one for every professional watching. It's a question that cuts right through all the complex procedures and timelines. If the foundational document that gives a lender the right to take someone's home is invalid, can anything built on top of it, the notices, the sale, the eviction, can any of it legally stand? This case is going to force the courts to answer.